All rise. The International Court of Justice is now in session. The judges are now entering the courtroom. The case before the court is the case concerning the Southern referendum. The parties are applicant, the Democratic Republic of Antara, versus respondent, the Velan Kingdom of Riveria. Applicant and respondent are each allocated 45 minutes to present their pleadings. The president of the tribunal will invite applicant to begin momentarily.
Apologies, Madam President. I believe you're on mute. You might need to press a small, I believe it should be
Apologies. I hope that's not a lesson to begin with. Allow me to welcome everybody to this grand final and to say what a pleasure it is to be here today, sitting on this bench. And I'm delighted to be here with two distinguished and valued colleagues, Judges Bruno Simma and Georg Nolte. So I'd like to say what a pleasure it is to preside over this tribunal. So with that, I'd invite the applicant to address the court.
Thank you, Madam President. Before I begin, can I just check we are not encountering any technical issues? Thank you. Madam President, Your Excellencies, may it please this court. My name is Brian Wong, acting together with my co-agent, Ms. Chang Wen-yi, and off-counsel, Mr. Alan Chong, on behalf of the applicant, the Democratic Republic of Antara. Now, Your Excellencies, at its heart, this dispute is about how far a state can be expected to tolerate interferences in a referendum which would determine whether one of its own provinces would remain part of it or secede. And to this end, this court is confronted with four questions. First, should evidence of various acts of interference in the Southern secession referendum be admitted in the present proceedings? Second, can those acts of interference be considered consistent with international law? Third, was Antara's suspension of Professor Hanlon's Pano account to prevent him from spreading misinformation that was directed at that referendum justified under the ICCPR? And finally, was its takedown of a botnet, which was also being used to spread misinformation, likewise justifiable? Now, in my 22 minutes before this court, I will be addressing the first two of these issues. My co-agent, in her 21 minutes, will address the latter two, and we respectfully reserve 2 minutes for our rebuttal. And I turn to the first issue, Your Excellencies, on the admissibility of evidence. And this comprises two pieces, which I will address in turn. The first being a recording of a conciliation meeting held between the Antaran and Riverian Attorneys General. And the second, a series of documents acquired from Ms. Walters in the course of her arrest for vehicular homicide committed while she was under the influence of alcohol. Now, the default position at international law, Your Excellencies, is that it is open insofar as the admissibility of evidence is concerned. And this was observed by Judge Santiago Torres Bernardes in this court's 1992 frontier dispute decision. And while the respondent has sought to persuade this court to depart from this position, we urge Your Excellencies to reject their contention. And indeed, I first address the recording. And our position is that it does not fall within the scope of the privilege conferred upon the contents of negotiations and settlements. Now, at page 2 of their written submissions, the respondents have interpreted this court's... Your Excellency, was there a question?
No.
My apologies. Now, the respondents have interpreted this court's 1992 frontier dispute decision as suggesting that this privilege applies only to suggested concessions. And they argue that Your Excellencies ought instead to return to the orthodoxy expressed in this court's predecessor's cause of factory decision. And this orthodoxy precludes the admission of any declaration, admission of liability, or proposal to settle. However, Your Excellencies, it is clear from this court's 1992 Frontier Dispute decision at paragraph 73 that it was applying the same standard laid out in Hawes Factory, that all declarations, admissions, or proposals were to be excluded. But more importantly, Your Excellency, this court was also clear in its Frontier Dispute decision that this standard laid out in Hawes Factory does not mean that everything and anything that transpires in the course of a negotiation will automatically be rendered inadmissible. This court may still take account of the content of settlement negotiations if to do so would not prejudice the respective cases of the parties in the proceedings. And for this reason, Your Excellency, in the Frontier Dispute decision, this court was willing to refer to prior negotiations, not to determine parties' respective positions as to where exactly the disputed boundary lay, but rather to determine their shared view as...
If I may ask a question, Counsel, you were speaking about the default position, and I wonder whether the default position should not be the secrecy and confidentiality of the negotiations. And I would, for example, look at the Salzburg resolution of the Institut de Droit International, Article 13, which speaks of the obligation to respect the secrecy of the proceedings and deliberations in conciliation procedures. I think it is quite natural to assume that this is the default position, and perhaps the court should be able to do something to maintain this default position.
Certainly, Your Excellency, we do recognize the importance of assuring parties that any statements made in the course of negotiations will not be used to their prejudice in the event that the negotiation falls through and the matter goes to trial. And this was recognized as the basis for this form of privilege in this court's Frontier Dispute decision. But here, Your Excellencies, we see at paragraph 44 of the compromise that the Bavarian Attorney General has made no admission of liability, no proposal to settle, nothing that could prejudice his case. All he has stated is that he is not denying that the documents say what has been reported. And this is really reflective of the shared view of the parties, as can be seen from paragraph C of the clarifications, where it states that parties have stipulated as to the authenticity of the documents. And for this reason, it is difficult to see what the prejudice caused the respondent would be from admitting the recording. And this brings me to the documents which form the...
Excuse me. So you are saying this is a special case. The default and regular position should be the exclusion of such materials, but here we are in the presence of a special case. Is that how I understand you?
Yes, Your Excellency, this could be articulated as a special case, and indeed, the situations in which what one party seeks to adduce will not prejudice the other party are likely to be few and far between. But we say that this is one such case akin to this court's own Frontier Dispute decision of 1992, and for that reason, the recording should be admitted. And this does bring me to the documents. Now, as outlined at pages 2 to 3 of our written submissions, we have argued as to why Entera did not commit any illegality in the course of their acquisition, as the respondents have alleged. But for the purpose of these oral proceedings, even if we were to accept that Entera did breach certain provisions of the Vienna Convention on Diplomatic Relations, this would not be dispositive of the question of admissibility. Now, at page 7 of their written submissions, the respondents are in agreement with us that this court can, in determining questions of admissibility of illegally obtained evidence, take reference to general principles of law. However, where we differ from the respondents is what that principle is. Now, they have argued for a categorical exclusion of illegally obtained evidence on the basis of good faith and some conception of the clean hands doctrine. However, our position is that, Madam President,
Please go on.
I'm so sorry. I believe you are muted.
Apologies. That's the last time. I apologize. I'll leave that on. I was, and I'm sorry to cut across my colleague, I don't know, Judge Nolte, whether you had a question. Also, no.
No.
I just wanted you to address the issue before you get too much into the fine detail. Surely there's a major argument this court would have to consider that if we were to approve the admissibility of these documents, one can imagine the very important precedent that would set in other cases. How would that act as a discouragement towards other potential parties from engaging in illegal conduct in such a case?
Now, Madam President, we certainly recognize that this court would not want to encourage other parties to do the same. And for this reason, where the illegal act in the course of which the evidence is acquired was intentionally committed with a view to acquiring the evidence, for example, in the cases of Methanex and USA, Libranenko and Turkey, and EDF and Romania, in those cases, the evidence should and was rightfully excluded for fear of encouraging other states to do the same. However, where the illegal act was not committed intentionally with the view to obtaining evidence, as, for example, in the ICTY's Radoslav decision, then that is a factor which favors admitting the evidence, or at least diminishes any concern about encouraging other parties to commit similar breaches. And given that, Madam President, was there a question?
No, I was just going to respond that one could imagine it wouldn't be very difficult for things to be set up to look as though there was legitimate search of the car. So I'm just inviting you to perhaps consider some of the deeper and bigger issues that lie behind here.
Of course, Madam President, we recognize that some states might be inclined to set things up in such a way to mask their actions, but international law recognizes a presumption of good faith as recognized, for example, in the Tanah Arika arbitration as well as the Lake Lanu arbitration. Now, of course, this could be displaced by clear and convincing evidence that a state was conspiring to hide its actions, the standard laid out in this court's Corfu Channel decision at page 17. But here, Your Excellencies, there is no clear and convincing evidence whatsoever that Antara has committed a conspiracy or attempted to purposely arrest Ms. Walters in order to acquire evidence. Indeed, they had no knowledge that Rivera had done anything of which they would have wanted to acquire evidence. The only clear and convincing...
Go ahead.
I think you're getting a bit far away from the actual problem of the documents now. So I would like to get back to something which I was always interested in, namely clean hands. Are you going to set out where you find clean hands, what sources you have for that? And are you aware, could you indicate a decision of the ICJ, of this court, where clean hands was dealt with? Has there been any jurisprudence that really took full, let's say, really applied clean hands? So if you could just give me a few indications there.
Your Excellency, this court did consider the clean hands doctrine in, for example, its certain Iranian assets decision, as well as its Gapsikawa Nagimaros decision, and also in its Nicaragua decision, albeit in the dissenting opinion of Judge Schreber. However, Your Excellencies, in all these cases, the clean hands doctrine was applied not in the context of whether evidence was admissible, but whether the claim was admissible. For this reason, this is not the appropriate principle to apply, contrary to the respondent's contention. And we say that on balance, in view of what the documents reveal and Rivera has done, an attempt to undermine what should have been a free and independent choice on the part of the Suthan people in respect of their destiny, we urge this court to accept the documents, to admit them, that it may test Rivera's own assertions at page 40, paragraph, my apologies, 41 of the compromise.
Maybe I haven't heard anything that had to do with my questions. Could you just indicate, so what would be the legal basis? How firmly anchored in sources would you find clean hands?
Your Excellency, this court, since its certain Iranian assets decision, declined to apply the clean hands doctrine in respect of whether a claim was admissible. It has never even...
If you say since that decision the court does something, does that mean that before that before that decision, the attitude of the court was different?
Well, Your Excellency, that probably was a misstatement on my part. This court has never applied the clean hands doctrine in an affirmative way. For that reason, it would not be appropriate for the respondent to rely upon it in the present case to bar admissibility of the documents. And so, Your Excellencies, I respectfully urge this court to admit them, that it may consider Bavaria's own claims at paragraph 41 of the compromise that what it did was not illegal and that it had done nothing wrong. And this indeed brings me to my...
Okay, I will let you go on after having responded to a question which refers to something which you have referred to at the beginning of your statement. You were referring to general principles of law, which would, let's say, answer the question whether evidence is admissible or not. I wonder whether it's necessary to think about general principles of law. Doesn't the court itself have the power to determine whether evidence is admissible or not? After all, Article 30 of the Statute of the Court gives the court the power to devise its own rules of procedure. And if such a rule would be part of the rules of court, the court could apply these rules. Why shouldn't it be able to just develop a precedent to that effect?
Certainly, Your Excellency, and this was also echoed in this court's armed activities decision at paragraph 59, where it was recognized that this court does have the discretion to decide what should or should not be excluded. Our suggestion is simply that it exercise this discretion in accordance with the practice of other tribunals and the factors they have considered, namely the gravity of what the evidence shows and the gravity of the illegality committed in their acquisition. And here we say this balance favors admitting the documents which form the basis of my second submission. And now, to be clear about what these documents involve, Your Excellency, we first see a massive campaign of political financing, 25 million euros given to pro-independence actors like the SAD and SIP. But more worryingly, we also see a campaign of misinformation that saw the calibration of pro-independence content to go viral at paragraph 37b of the compromise, the deceiving of Ontario voters into thinking that that information came from indigenous Suthan sources, and the use of the dark web to mask the botnet that was being used to spread this misinformation. And this we see at paragraph 32. Now, all this was with a view to guide the hearts and minds of Suthan voters towards secession, with a view to eventually absorbing Sutha, the newly independent Sutha, into Bavaria. And we say that this amounts to a breach of the principle of non-intervention outlined by this court in its Nicaragua decision. Now, this principle prohibits any action which has a bearing on matters in which a state is entitled to decide freely and which ought to be made freely and independently. Now, at page 11 of their written submissions, Your Excellencies, the respondents have argued that only military intervention, occupation, or furnishing assistance to armed groups will amount to a prohibited intervention. But this, Your Excellencies, is not consistent with this court's Nicaragua decision. At paragraph 205 of that judgment, it stated that prohibited intervention will be particularly obvious where it involves military action or support for armed groups. But this necessarily means that the categories of intervention cannot be limited to only such acts. Indeed, the United Nations General Assembly, in its 1981 Declaration on Intervention and Interference, noted that false or distorted news was capable of interfering in the internal affairs of states. And indeed, in its...
Mr. Chong, just to stop you there, I wonder, though, if you can point to, this is obviously an area of law that has only recently, with the rise of the web, become significant, the rise of cyber activities, but can you point us to any state practice where it's been conceded by a country or argued by a country that this type of interference, which is surely all around us all the time, constitutes a violation of international law? I'm aware, for example, that the United States has always been very, very careful not to make such an argument in the context of evidence of cyber involvement in election activities there. So can you point us to any relevant state practice in this context?
Certainly, Madam President. Now, we do note that many countries like Canada, New Zealand, the US, India, Australia, South Korea have all passed legislation that attempts to either regulate covert funding or regulate forms of electoral interference, which does include misinformation. Now, of course, the lack of any overt statement in respect of such acts cannot necessarily be taken to mean that states do not consider this interference. The failure to voice concerns or objections may well be due to diplomatic or political reasons. But this
Well,
need not
forgive me, sorry. What's your best legal argument then? What's your best argument to support the idea that this could somehow be illegal, your strongest one?
Our strongest argument, Madam President, is that the original articulation of the non-intervention principle is capable of capturing deceptive attempts to undermine the will of a people expressed through what should have been a free and independent choice. This is evident from the UN General Assembly's...
You're drawing direct analogy between this behavior and the activities of the Contras.
Not really, Madam President. The UN General Assembly, in its 1981 declaration, expressly recognized that false or distorted news was capable of amounting to an intervention in the affairs of other states. And in its 1970 Friendly Relations Declaration, the UNGA stated that all forms of interference against a state, its political or cultural elements, or its choice of political systems would be capable of amounting to a violation of international law. And given that this is exactly what Bavaria has attempted to do by deceiving Southern voters into voting in favor of its desired political outcomes, this means that the non-intervention principle, as originally articulated and conceived by both this court and the UN General Assembly, was breached by Bavaria's attempts to deceive Southern voters, thereby rendering a choice which should have been free and independent unfree. But Your Excellencies, I do also note the question of whether this misinformation campaign could even be attributed to Bavaria in the first place. And here we note that at page 10 of their written submissions, the respondents have argued that the case of Nicaragua sets a very high threshold for the attribution test to be made out. My apologies, Your Excellency, did you have a question? Judge Nolte?
I'm still thinking about the concept of intervention and the standard to be applied. Our court has used the term coercion, and I think everything turns around the term coercion here. And I understand that you are referring to General Assembly resolutions prior to that, but I think the court very deliberately and carefully chose the term coercion in the light of the Nicaragua case, but also having other possible cases in mind. And would you not agree that the term coercion is difficult to apply to lesser focused conduct like that of trying to influence an election or referendum by a misinformation campaign? Is that not too diffuse a behavior to be termed coercion, because it is not as focused as the term coercion would suggest? And would it not be also the purpose of the principle of non-intervention to protect against more focused forms of pressure?
Thank you for the question, Your Excellency. Before I respond, I note that my time has expired. If I might just respond to His Excellency's query. Thank you, Madam President. Now, we would note at the outset that, yes, the standard laid out in Nicaragua was coercion, but this was because, as this court observed, that its description was confined only to the aspects of those principles which appeared to be relevant to the resolution of that dispute. Now, as to whether more diffuse or focused forms of intervention ought be recognized, now we would say that this misinformation campaign was very much focused. It saw very calibrated information, pro-independence information, with a deliberate attempt to alter the way that Southrons voted. This is as focused as it could possibly get with respect, Your Excellencies. Now, my time having, of course, expired, this concludes my submissions. Thank you, Your Excellencies. I yield the floor to my co-agent.
Thank you very much, Mr. Wong. So, invite, yes, Simma to the podium. You have the floor.
Thank you. May it please this court. My name is Chang Wen-yi, second agent for the applicant. Now, my co-agent submissions have centered around the need to protect the referendum vote. And in my 21 minutes before this court, I will address the measures Antara took to safeguard the integrity of this secession referendum. Our submissions are that firstly, Antara's suspension of Professor Hanlin's panel account was a justified restriction of his human rights. And secondly, Antara's takedown of the Luna botnet violated no international law. Now I begin with the dispute surrounding the suspension order, which had been issued for an initial period of 1 year and later extended owing to Hanlin's involvement with the elections and the botnet, as stated at paragraph 3 of the clarifications. And while we recognize that Professor Hanlin has a right to freedom of expression under Article 19 of the International Covenant on Civil and Political Rights, the ICCPR is unequivocal that this right is not absolute. States like Antara may place restrictions if they are provided by law and necessary under Article 19, subparagraph 3. And while the respondent at pages 20 to 23 of their written submissions argue that the suspension was neither legal nor necessary, my submission would demonstrate how this was a justified restriction, not only because there were adequate safeguards within the legislation, but also because the suspension was a calibrated measure of last resort. Your Excellencies, I begin with the first requirement that the restriction must be provided by law. And here, the instructive test for this court is whether the statute laying down the restriction has in place adequate safeguards against arbitrary interference, as stated by the human...
Forgive me just jumping in. I'm sounding a bit impatient on the law, but I just wonder if you could point us to any decisions that are comparable that might be helpful for this court taken or views rendered by, for example, the United Nations Human Rights Committee on this provision, or decisions of perhaps regional human rights courts. Could you point us to anything that would be analogous?
Madam President, if I understand your question correctly, would it be on the persuasive weight of the Human Rights Committee's jurisprudence? Because if it is...
Not so much in itself. I was just wondering in terms of the compatibility of the human right to freedom of expression with the restrictions set out in your national law. In this particular context, have there been many explicit discussions of weighing the right and the restrictions in a similar context?
Yes, this has been discussed by numerous cases in human rights jurisprudence by the Human Rights Committee in Ross and Canada in 2000, by the European Court in its Sanova, Netherlands decision in 2010, that when we look at the provision by law requirement, we can have recourse to whether the domestic legislation has in place adequate safeguards to protect individuals against arbitrary interference. And Madam President, this is also reflected by the Human Rights Committee's General Comment 34 at paragraph 25. The respondent at page 21 of their written submissions contend that there is arbitrary decision-making in the present case. But Section 5 of the Protect Antara Cyberspace Act clearly imposes multiple requirements on the executive and the judiciary before a decision may be made. And here I wish to highlight 3 key aspects for this court. The first is that the DPCA cannot unilaterally issue an order. It must make an application to an Antaran federal court, and under Section 5, subsection 3 of the Protect Antaran Cyberspace Act, the court must be satisfied that it is necessary to grant the order based on a preponderance of evidence. Secondly, Subsection 2 stipulates that the person accused of posting election misinformation has a right to be heard before the court. And last but not least, subsection 4 sets out the considerations that the court must take into account, like the availability of reasonable alternatives and the impact that such an order would have on public interest. And those are similar considerations to those in international human rights law. Therefore, we submit that the present restriction governed by Section 5 of the Protect Antara and Cyberspace Act was provided by law.
I have little doubt that the legislation is in conformity with Article 19. I wonder about the application of that legislation, and I wonder why it was necessary to impose a harsher measure on Professor Hanlund, in addition to the measures that had already been imposed, which was the flagging of certain of his posts. And if I'm not mistaken, the taking down came at a moment after a demonstration had turned violent, but I did not see any connection between Professor Hanlund's conduct and the demonstration turning violent. And is that a sufficient reason to restrict somebody's human right that something happens which is beyond his control? So is that really a proper application of the law? Thank you.
Thank you, Your Excellency. Now, to first address your first concern as to why it had to impose a harsher measure after flagging mechanisms had been used at paragraph 24 of the compromise. It is precisely because these flagging mechanisms had not proven effective, given that 63% of Professor Hanlund's posts had been flagged, indicating that he had continued posting unlawful content. And it was on this basis that Antara found it necessary to impose a harsher restriction, with the referendum being days away. But as to Your Excellency's second concern, if Your Excellency...
Excuse me, so the reason was not the violent demonstration. The reason was that he was continuing to do something which the government did not like. But the measure imposed on him, the flagging, was continued. So everybody could see that these information are questionable. So why was there a problem?
Perhaps I can answer your second concern in your previous question, Your Excellency. And that is because we are not relying on the violent demonstration at paragraph 25 of the compromise to justify our restriction. We understand that the connection between Professor Hanlund's expressions and the violent demonstration is not immediately clear. What we are relying on is the ground of public order, which has been interpreted to go beyond public disruptions and also extend to situations where the threats to democratic processes are concerned, as stated by the Human Rights Committee in its 2005 Zhongzhou and Korea decision. And where misinformation in the lead up to elections and referendums are concerned, this is a situation where public order would be threatened. And in fact, Your Excellency, it is not the case that Antara imposed this restriction because it did not like what Professor Hanlund was posting. This was made on objective evidence that Professor Hanlund had been recalcitrant in posting misinformation, as seen at paragraph 17, 22, and 23 of the compromise. And allow me to briefly bring this bench through the facts. First, at paragraph 17 of the compromise, Professor Hanlund made allegations of martial law, despite such allegations already being shown by various media organizations and the government to be false. At paragraph 23 of the compromise, he makes 800 posts in the span of 2 months, with many shown by independent observers to be false. And specifically at paragraph 23C, he makes claims of electoral fraud, alleging that the referendum would not be a free and fair one. And it was because of this repeated pattern of posting misinformation that Antara sought to restrict his right to freedom of expression by imposing the suspension order.
But that was not the reason given by the court, if I'm not mistaken.
Your Excellency, the reason given by the court at paragraph 27 of the compromise is twofold. It did refer to the protection of the integrity of the electoral process as well as the violent conduct by Professor Hanlon. But for our oral proceedings today, we will rely on the former reason given by the court at paragraph 27. If I could also address Madam President's concern.
It's just a point of a question that I found it hard to understand. I was puzzled. Could you explain, or is there any relevance to the fact that the suspension order was made against a private corporation, against Pano, rather than Professor Hanlon himself? Is that relevant?
It is not relevant that the order was made against Pano rather than Professor Hanlon directly, insofar as the ultimate effect of the interference or restriction would be felt by Professor Hanlon. And so the key contention before the court would therefore be the restriction of Professor Hanlon's right to freedom of expression. And this has been addressed by the European Court of Human Rights in its 2020 Flavu and Russia decision, where in that case, the Russian government also made an order to the telecoms operator, but the court examined the restriction on the individual's right to freedom of expression. Your Excellencies.
May I just on this point, and even if this court were to follow your argument and to support your activities, I'm again concerned about the wider implications of surely there is at least one or more school of thought that would say, in response to misinformation, what you need is a campaign of better information, that you should meet misinformation not with prosecutions but with more and better information. If this court were to endorse your argument, it just strikes me it could be a cover for very repressive regulation, national regulation. Do you have any observations on that concern?
Yes, Madam President. And in fact, this is a concern the respondent also raises at page 23 of their written submissions, that Antara should have used the alternative of fact-checking or proactively communicating true information. But when we examine the proportionality of a restriction, it is not merely the least intrusive instrument, but the least intrusive instrument that can achieve the protective function, as stated at General Comment 34 at paragraph 34. And such alternative measures would not be feasible given the fast speed in which misinformation spreads, as the European Court of Human Rights in its 2015 Delphi and Estonia decision had recognized, that the ease, scope, and speed of dissemination of information on the internet would exacerbate the effects of unlawful speech. And therefore, such an alternative...
I beg your pardon. May I ask, can you point to any cases of this court where the court has relied on a general comment for one of the United Nations human rights treaty bodies as a source of jurisprudence?
Madam President, that is the 2010 Diallo decision at paragraph 66. It referred to the Human Rights Committee decision of Marifodo and Sweden, and also General Comment 25 regarding Article 13 of the ICCPR on the rights of aliens. And therefore, general comments do have persuasive weight before this court. Your Excellencies, this concludes my first submission, but it was not only Professor Hanlon who had posted misinformation. In my submission, in the second issue will deal with the Luna botnet, which had propagated misinformation through infecting over 30,000 devices. And the crucial question for this court is what steps Antara can legitimately take to stop this spread of misinformation. Our primary argument here is that the takedown of the Luna botnet was not a violation of Riverian sovereignty. And the customary principle of sovereignty, as recognized in this court's 1986 Nicaragua decision, also applies to the cyberspace as evinced by state practice and opinio juris of multiple states, including the US, New Zealand, the Netherlands, Switzerland, Guyana, and Japan. And there, yes, Your Excellency.
I must say that I've never heard an allusion or a reference to sovereignty as sovereignty based in customary international law. Isn't sovereignty a principle that you would have to be located at some higher or some other level? And if yes, where would you derive sovereignty from as something which, in a way, is relevant and creates binding obligations? Is it a question of custom? That means if sovereignty could be taken away, let's say in a region, or change over time, etc. You are aware, of course, that, I don't know, about 20 years ago, in academic literature, sovereignty was something entirely different from what it had been before. Now it was a sovereignty to protect, etc., etc., etc. Much of this is gone again. So the question is, how does sovereignty change? Does it change by way of state practice and opinio juris, or otherwise?
Your Excellency, sovereignty was traditionally referred to as a principle, but this court in its Corfu Channel and Nicaragua decision also recognized that sovereignty is an obligation that states owe to each other and an obligation that can be violated.
Oh, wait a
Where
minute. Can you really say sovereignty is an obligation, like taking from Corfu Channel, or do you mean territorial inviolability, things like that flow from sovereignty?
I stand corrected, Your Excellency. Our position is that sovereignty must be respected and such that the territorial integrity of states must not be violated. But in the context of the cyberspace, the state practice and opinio juris do suggest that this obligation of sovereignty can only be violated in 3 situations: where there's physical damage, loss of functionality, or an interference with an inherently governmental function. And our submission is that all 3 situations are not applicable here. The reason why we say this is because paragraph 4 of the clarifications make clear that Operation Moonstroke did not result in any harm to any of the devices, and also did not cause any negative impact on users or the network experience. And therefore, there is no physical damage or loss of functionality. Perhaps the more contentious point is whether there was an interference with an inherently governmental function. But the authors of the Talent Manual have helpfully provided illustrations of when this would be the case, including deletion of data where it concerns tax collection or social security services, none of which occurred on the present facts.
What kind of source is the Tallinn Manual 2.0?
And may I just supplement Judge Simma's question? Do you know whether the court has ever quoted a kind of document that you are referring to right now, which is the Tallinn document? Has the court ever quoted such a kind of document, and how is it to be distinguished from, let's say, documents which have at least more frequently been quoted? Thank you.
Thank you. To answer Your Excellency's questions together, first, Judge Simma's question. The Talent Manual would be a subsidiary source of law in Article 38(1)(d) of this court's statute to interpret Articles 38(1)(a) to Articles 38(1)(c). And as for Judge Nolte's question on the source of the Talent Manual, while similar sources have not been yet cited by this court, the author of the Talent Manual, Professor Michael Schmidt, has been cited in Judge Albury's separate opinion in the War Advisory Opinion in 2004 at page 258. And so we urge this court to consider the Talent Manual.
So, sorry, but the Tallinn Memo, you mentioned one Professor Schmidt, and I happen to know him. Do you know any other authors, and would you consider these authors to necessarily belong to the category of academic voices that you have in Article 38? What is it? Yes. I mean, aren't you a bit quick in elevating the Tallinn Manual to the Article 38 categories? Would you consider the authors to belong to the... I mentioned before we entered the courtroom, I mentioned to my colleagues that in an older version of the bench memo, what was said on this issue was, there you really, I mean, you have to be very critical, and only authors like Grotius or Brownlee would qualify. Now, would you say Schmidt and unknown others are Grotiuses and Brownlees?
Please answer carefully.
If I could first assist this bench with the other authors of the Italian manual, Professor von Hayek of the Virginia European University, Dr. Louise Arimatsu of the UK Chatham House, and while they do not rise to the level of Grotius or Brownlee, we submit that in the context of cyber operations and the cyberspace, they should be considered eminent publicists given the fast developments of cyber operations, and they are well acquainted with this.
Okay,
Yes,
I accept your argument for the moment, and I don't want to call into question the authoritative character of the colleagues who have formulated the Italian manual. My problem is that the Italian manual is a result of a collaboration of the NATO Center of Excellence, so that it is a group of colleagues which self-design themselves or within a certain political context which is not a universal one. Don't you think that even if we assume that these colleagues fulfill the criteria of Article 38 of the statute, the way they are collectively acting, the framework in which they are collectively acting, somewhat devalues their authority for the purpose of identifying universal rules?
Your Excellency, I would have to respectfully differ from your assumption that they are only from the NATO body. And this is because when the Italian manual was drafted, the inputs of more than 50 states, including China, US, and Germany, were also sought. And therefore, our submission is that it is sufficiently representative. I note my time, Your Excellencies, and this concludes my submissions. Thank you.
I have before you can escape a little follow-up to that. I mean, what does it mean with regard to the authority of something like the Italian manual, that the authors kind of sent out questionnaires, etc., and voices of 50 countries were assembled? What this, if you answer, let's say, a questionnaire, or otherwise state your voice, does that really elevate the authority of the document? Or necessarily?
Well,
so?
Judge Simma, it is not merely a questionnaire or answering certain questions. Our position is that the Italian manual received inputs and discussions between experts of multiple states, up to 50 states, and was also recently endorsed by the UN Group of Governmental Experts report in 2021 before the UN General Assembly. Unless Your Excellencies have any further questions, this concludes my submissions. Thank you.
Thank you very much, Mr.
Can you see and hear Your Excellencies?
Yes, Ms. Sweeney, you have the floor.
I'm actually Miss Canary. We're just using the same computer.
Oh, okay. I beg your pardon, Ms. Canary.
No problem.
Ms. Canary, forgive us. Oh, you definitely have the floor.
Thank you. Madam President, Your Excellencies, may it please the court. My name is Marta Canary, and I appear on behalf of the respondent, the Valen Kingdom of Rivaria. My co-agent is Ms. Hannah Sweeney. I will speak for 22 minutes. My co-agent will speak for 22 minutes, and we respectfully reserve 1 minute for rebuttal. I'll be addressing the first two questions presented today. First, the admissibility of inviolable diplomatic documents in the May 30th, 2021 recording as evidence in these proceedings. And second, the legality of Rivaria's support for the Suthen referendum. Turning first to the question of the evidence. And here we accept the law as has been put by the applicant, that with regards to its evidentiary regime, this court generally accepts all evidence proffered to it unless there is a specific exclusionary rule to the contrary. And thus the critical question here is whether there are any applicable exclusionary rules. And here there are two. First, the rule precluding the admissibility of evidence from settlement negotiations quoted by the applicant would apply to the recording. And second, the inviolability of the documents seized in the search of Emma Walters' vehicle would render them inadmissible because they are a breach of Article 24 of the Vienna Convention. So to turn first to the question of the negotiations. And here we once again accept the law as has been put by the applicant, that this court does not take into account declarations, admissions, and proposals made between negotiations between the parties when such negotiations have not led to a complete agreement. This was stated first by the court's predecessor in Factory at Chorzo at page 19, and was characterized as a rule of customary international law in Qatar Bahrain at paragraph 40. Here, applicant has made two key arguments with regards to this rule. First, they have argued that the rule does not preclude the admission of shared views of fact. And second, that the rule does not preclude the admission of evidence when it does not prejudice the party's claim. So to turn first to the question of shared views of fact. In this respect, applicant has mischaracterized the rule. The paragraph they cited, paragraph 73 of El Salvador, Honduras, stated that the court may take into account shared views of fact as to the basis and extent of their dispute. In other words, shared views of fact as to their initial contentions. And for example, in frontier dispute cases, that has meant the location of a particular disputed island or the location of a particularly disputed frontier line. Here, there is no attempt to admit a shared view of fact, and as such, the rule should apply. And second, applicant has...
Can I just stop you there, Ms. Canary? I'm just puzzled as to, with respect to the recording, with the transcript recording, why, if it was in this question of should the court actually impute an intention by the parties to keep these documents confidential, because it's not said explicitly, it wasn't said explicitly during that time. So given its relevance, I'm just wondering if can you comment on that? Why should we as a court impute that intention to the parties when it's not explicit?
No, Your Excellency, we should not impute that intention, and that's for two reasons. The first is, though, has been cases where parties have indicated in their special agreement that the court could not use evidence from negotiations, for example, in the Gulf of Maine case. In all other cases in which this court refused to consider evidence from negotiations, including Mali, Burkina Faso, and El Salvador, Honduras, there was no such statement or agreement by the parties. And indeed, this court chose not to admit evidence from negotiations even when the parties did not object, even when a party did not object to that inclusion, showing that it felt that it could take such a decision on admissibility sua sponte. And with regards to applicants' claim that the court can admit evidence as long as it does not prejudice the party, there is no support for that in any of the jurisprudence of the court. The court has never stated such a rule. But even to take applicants' case at its highest and to suggest that there is such a rule, it is unclear what evidence here could be introduced that would not prejudice Rivaria's claim. Applicant has stated that the evidence is introduced in order to authenticate the documents, and that is the shared view of fact. But the corrections and clarifications before this court, specifically paragraph C, clearly state that the parties have already stipulated to the authenticity of the documents, and as such, it would not be introduced for that reason. Now, to turn, Your Excellencies, to the question of the inviolable diplomatic documents. And it's important to note here that at oral submissions, Rivaria is not asking for a categorical rule excluding the admission of unlawfully obtained evidence. Merely a rule recognizing, or merely the recognition of the rule that inviolable diplomatic documents cannot be admitted before a court. And that's for two reasons. Sorry, Your Excellency. And that's for two reasons. First, the breach of Article 24 of the 1961 Vienna Convention, which states that the archives and documents of the mission are inviolable at any time and wherever they may be, is an ongoing and an intentional one. and therefore under Article 30 of the Articles on State Responsibility, which states that acts, internationally wrongful acts of a continuing nature must cease, applicant should not be able to introduce these inviolable diplomatic documents as evidence. And it's important to note here, Your Excellencies, the applicant has derived a great deal of significance from the claim that the violation of diplomatic law was not an intentional one. But it's hard to see how that follows from the facts. If you look at paragraph 41 of the 38 rather of the compromis, you can see that even when applicants recognized the documents as diplomatic archives, it photocopied them and continued to hold on to them. And this is clearly.
What if the wife of the ambassador would have lost these documents? Would the same, would you also say it would have been a violation to look at them or to photocopy them if a policeman happened to find them on the street?
Yes, Your Excellency. And we can see that both from the text of the treaty and from the practice of domestic courts. So the text of the treaty clearly states that the documents and archives are inviolable at any time and wherever they may be. And indeed, during the drafting of the convention, amendments that had been introduced to suggest that the documents should have been restricted to the diplomatic transport, diplomatic bag, and diplomatic premises were rejected.
Excuse me, how can you see whether this is a diplomatic document which ought to be treated as inviolable without looking at it or reading it?
Yes, Your Excellency.
I mean, we are getting emails every day from law firms, etc., which have long notes at the end dealing with these matters. So how far would you go in reading a document before you recognize or before you say, all right, now I have to stop? But you need to do some reading, right?
Yes, Your Excellency. And it is not Rivaria's contention that the mere reading of the documents constituted a violation. Simply that once applicant recognized the documents as diplomatic archives, it should have turned them over. And this was indeed of issue in the Eritrea-Ethiopia Claims Commission in 2005, in which a party seized an unlabeled box that had inside a series of diplomatic archives and passports. And Eritrea argued—
by what indications should somebody finding the document, according to Judge Nolte on the street, and start reading, what would be the indicia telling you that this is a diplomatic document, or maybe not something that a reporter of a newspaper has assembled? What would it need? Would it have to have some kind of a stamp, or what would make it so, let's say, dangerous?
No, Your Excellency, there would not be a need for it to be labeled. And this is clear both from the text of the treaty, which is distinct, which shows that while Article 27 states that diplomatic correspondence in the diplomatic bag must be labeled, Article 24 does not. And further, the fact that amendments asking for archives to be clearly indicated using official seals was also rejected. And therefore, this is a very fact-specific inquiry. Had, for example, the diplomatic archives not been so clear, it would have perhaps taken a longer time before the obligation to return or destroy these documents attached. However,
where do you see an archive here? You say the diplomatic archives. Is that a diplomatic? Where do you find it? Is that a diplomatic archive, the paper, or the let's say the hand, the baggage of a diplomat's wife, part of the archive?
Your Excellency, here we argue that it is a document under Article 24, the archives and documents of the mission. Your Excellency, with regards to this point, the UK Supreme Court in 2018 in the case Banquote 3 held that documents and archives of the mission involve or include any document storing information. And it is also—
I really have a problem with that tendency of international lawyers from all kinds of continental European countries to really give UK court decisions a higher value because of something I don't understand, maybe the Oxbridge accent of the people that read them out, etc. What okay, you find one UK decision, so what does that prove?
Your Excellency, I too resent the Oxbridge accent. No worries. Your Excellency, it is not just the UK courts that have found that documents, inviolable diplomatic documents, cannot be admitted in a court of law. US courts have found that as well in the Southern District of New York, and also
I'm just going to interrupt you there just to ask you, because it is related to this question you're answering of Judge Simma's. I'm just trying to work out in your answers, what is the category that we should put this principle for which you're arguing? Are you saying, is it a rule of custom? Is it a general principle of law recognized by all civilizations using the court statute? Whereabouts are you pigeonholing it? Or is it a treaty breach? Yes. Please.
Yes, Your Excellency. The obligation not to introduce evidence that is deemed inviolable is a treaty obligation under the VCDR Article 24. And the way that it is applied in this particular case is related to the court's function as deciding disputes in accordance with international law. And as the court's predecessor stated in the Mavromatis concessions case, with regards to procedural rules, when the statute is silent, when the statute and the rules are silent, the court should adopt the procedural rule that is most in line with international law. And so
sorry, Ms. Canary, allow me just to remind you, though, that the International Court sees itself in quite a distinct sphere to all the courts that you've mentioned. And in fact, there are many cases. I'm thinking of my fellow Australian President Spender in the South West Africa cases, who asserted a very broad rule of the court had considerable power to admit all types of evidence, and that it didn't see itself as a slave, as it were, to municipal rules of law, and that the court had the ability to evaluate many forms of evidence. So I just wanted to be clear about the nature of the legal source that you're relying on.
Yes, Your Excellency. And it is true that with regards to the admissibility of evidence, this court has placed special emphasis on its highly qualified and experienced bench, and the fact that the disputes are taking place between sovereign states. However, when it has found the existence of a rule of international law, as it did, for example, with the negotiations exception, it has used that law to exclude or to render inadmissible documents. And though this is a very rare case for the court, it is still one that would apply to the case at bar. And I'll turn now, Your Excellency, to the merits of the claim, the legality of Rivaria's support for the Suthen referendum. And here, applicants' claim rests on one ground, that the Rivaria support breached the principle of non-intervention. But this claim, to make out this claim, requires a finding of attribution under the law on state responsibility. And so I'll turn first to the question of attribution. And here, Your Excellencies, applicant has put forward a theory of effective control that under Article 8 of the Articles on State Responsibility, which reflects attribution of conduct of non-state actors, that Rivaria wielded effective control over the SAD and the SIP. Now, this standard was elaborated in this court's 1986 judgment in Nicaragua.
What are the words or the terms by which Article 8 qualifies acts as being, or qualifying the activities of the non-state actors as state activities? So
yes, Your Excellency.
Yeah.
So, apologies, Your Excellency. The language of Article 8 refers specifically to instructions, direction, or control. And so with regards, for example, to instructions, which this court considered in its genocide decision at paragraph 400, these instructions are required in respect of each operation in which the alleged violation occurred. Now here, Your Excellencies, the evidence of Rivaria providing support to the SAD and SIP is limited. We have evidence of financial contributions to Valen religious organizations, which then provided the funding to the SAP and the SID. And we have evidence of technical guidance provided by the Rivarian External Affairs Ministry to the Rivarian ambassador. And here, based on that evidence and with the guidance of this court's decision in Nicaragua, it would be hard to find effective control demonstrated by fully conclusive evidence. And it is precisely fully conclusive evidence that is required per this court's statements in genocide at paragraph 209. Now, in Nicaragua, this court found an absence of effective control despite evidence showing that each Contra offensive was preceded by an infusion of US funding, totaling hundreds of millions of US dollars. The fact that the Contras were equipped, that they were trained, that they were provided with logistics and support aircraft. This court did not find effective control there. And they indeed also rejected a but-for test for effective control, which applicant argues in their written submissions. In other words, even if it could be made out that the Contras or the SAD and the SIP could not have conducted their operations without the support, that would still be not enough to show attribution.
This is something that has vexed me for a long time. It was a problem for the International Law Commission, of course, in connection with Article 8. It was a problem for the court in the genocide cases, and I was there more or less in both instances. And my question to you is, isn't it dangerous with regard to the rising let's say, influence or power of non-state actors to set such a high standard for attributability to a state, that you say, if the non-state actor has not gotten any directions, control, etc., if it more or less the relationship between the non-state actor and the state that you're looking at before the ICJ was more or less that in the Nicaragua case, that lets a lot of cases that might be terrorist cases, environmental spills of all kinds, etc. Just let's escape from the law. Escape from the law in the sense that you cannot really pinpoint a state which will be responsible, which will have to pay.
Your Excellency, 2 points in response to that. This court did consider that very objection or that very argument in genocide when it was asked to make adverse inferences with regards to the FRI's possible provision of instructions to the VRS. And it declined to make those adverse inferences precisely because state responsibility is of such a significant import in international law. But respondent would also contest, and this is our second point, that to impose a high standard of attributability would let these actions fall through the gaps of international law. This court has recognized, for example, in Nicaragua, that certain kinds of support by themselves can be violations of international law if they meet the requisite elements of a non-intervention, for example. And there are other standards of attribution, for example, adoption and acknowledgement under Article 11. And so respondent does not feel that this conduct can easily fall through the gaps. And to turn then to applicant's case at its highest, even if attributable, the conduct would still not meet the bar of non-intervention, which requires, as applicant stated, that the intervention be in the domain reservé of a state using coercion. That's paragraph 205 of Nicaragua. And this court and the Friendly Relations Declaration have defined coercion as the subordination of a state's sovereign rights. And here, the misinformation campaign, even if it is found to be attributable, would not meet that high bar for two reasons. First, because it complied with domestic campaign finance laws, which represent a formal lawmaking opportunity for the people of the state to express their preferences regarding foreign participation in elections. And second, and most crucially, because it did not affect the state's ability to conduct the referendum, but rather voter attitudes. And the resolution cited by applicant, Your Excellency, is thus not custom in this matter. And now I defer to my co-agent for the remaining claims. Thank you.
Thank you, Ms. Canary. Ms. Sweeney, you have the floor.
You have the vote. Just a question, because we need these names in our discussion. Now, the lady that preceded you, what was her name?
Ms. Canary.
Okay.
Yes, Your
I can't
Excellency.
hear them.
Marta Canary was the
Awesome.
first respondent, and I'm Hannah Sweeney, the name cited at the bottom now for the.
Well, thank you. Mhm.
Please proceed, Ms. Sweeney.
Madam President, Your Excellencies, it is an honor to appear on behalf of the respondent, the Velen Kingdom of Bavaria. I will be assisting the court today with the third and fourth submissions. The third in relation to the suspension of Professor Liam Hunland's social media Pano account, and the fourth in relation to Antara's unlawful interference with computers and devices operating on Bavarian soil. So turning first to the issue of Professor Liam Hunland's Pano account. Now, it is worth briefly noting as a preliminary matter that while the applicants did not contest our standing in the oral proceedings, they did in their written submissions. And I would like to briefly note that Bavaria has standing to bring a claim on behalf of Professor Hunland because it has met the threshold for diplomatic protection, given Professor Hunland is a Bavarian national and has exhausted local remedies within Antara. So then turning directly to the merits.
I beg your pardon, Ms. Sweeney, it's only because you've dangled this question of nationality before us. Actually, what this court said about genuine links, for example, in the Nolte case, how does that bear on your argument that there's clearly an attenuated link here between Bavaria and British Hanlon? So can you address that in a bit more detail?
Certainly, Your Excellency. On the first note, I would point out that the ILC has considered this and the commentary on the draft articles of diplomatic protection at Article 4, Paragraph 5, stating that in the Notenbaum case, this genuine link was not intended to represent an additional requirement for establishing diplomatic protection. But even taking applicants' claim at its highest and presuming we should apply this test, Bavaria submits that the facts of Professor Hunland can easily be distinguished from the incredibly tenuous connection between Mr. Notenbaum and Liechtenstein in that case, given Professor Hunland has been a Bavarian national for a longer period of time and maintains personal property in Bavaria pursuant to paragraph 28 at the compromis. And we believe this alone meets the threshold that his connection to Bavaria is more than extremely tenuous, justifying diplomatic standing in this case. So moving to the merits of the submission.
What do you mean by diplomatic spending? Spending. That's probably a wrong expression, right?
Your Excellency, I appreciate the clarifications. I intended to say that we have met the requirements for diplomatic protection in order to have standing to bring a claim on behalf of Professor Hunland. Now, moving to the merits, this claim pertains the civil liberties of Professor Hunland, a politically active and longtime supporter of Suthen independence, whose voice was silenced in the lead up to a self-determination referendum. Now, the salient issue here is whether the restrictions complied with Article 19, subsection 3 of the ICCPR. And we agree with the law as put by the applicant in this case, and taking their claim at their highest and presuming that it was provided for in law under the Protect Antara Cyber Act found in Annex 1 of the compromise, the respondents will focus on the necessity to an enumerated ground and whether or not it was proportional in reaching that end. So considering first the prong of necessity to an enumerated ground, we would consider first the General Comment 34 produced by the Human Rights Committee as the interpretive body for the ICCPR, which found in paragraph 35 that a state should show.
Excuse me. You say that there's the Human Rights Committee on top of the ICCPR, and it is the interpretive body for the covenant. What does that mean? That a treaty body is the interpretive authority or whatever for the covenant? Does that mean that interpretations done by the treaty bodies like the Human Rights Committee have what are they, authentic, highly credible, more worth than what Professor Simma writes? So can you just locate this a bit more specifically? What is the interpretive body? That's an expression that I have not read, but I'm sure you have, but I haven't. So I need some clarification here.
Your Excellency, in this regard, the Human Rights Committee is an expert body of 18 individuals considering how the International Covenant on Civil and Political Rights is interpreted, both through their communications and views granted for communications between states when they're subject to the optional protocol, but also by delivering general comments that do provide their understanding of details teasing out through. It is worth noting that it is not a binding source upon this court, but rather, as our friends for the applicant have mentioned already, in the Diallo case at paragraph 66 and 68, this court did find that great weight should be given to these bodies that specialize on the treaties that they provide. Now, in this particular matter—
Sorry, I just have this question of information. Did this court actually say great weight should be attributed?
Yes, Your Excellency, that is the text of paragraph 66 in Diallo.
Thank you.
Now, further, in the general comment itself, at paragraph 35, it states that a state must articulate in specific fashion with precisely creating a direct and immediate connection between the alleged enumerated threat and the speech that is being restricted. So the question then becomes today whether or not the applicants were able to show a direct and immediate connection between Professor Hunland's Pano account and the alleged threat to one of the enumerated grounds under ICCPR Article 19, subsection 3. Now, the account was suspended under PACA subsection 5, which regulates election misinformation. Further, we can see in paragraph 26 of the compromise, the cited reason for the suspension was that it was likely to undermine the inviolability of the referendum and to incite imminent lawlessness in relation to it. So now that we must ask whether or not this connection was sufficiently met today. And on the consideration of misinformation, it is important to note that the general comment at paragraph 49 also states that the covenant does not permit the prohibition of expressions of an erroneous opinion or incorrect interpretations of events. Now, we can all further see in the European Court of Human Rights case, Slavo v. Ukraine, at paragraph 113, that the freedom of expression does not prohibit the discussion or dissemination of information, even if it is strongly suspected that that information may not be truthful. Now, a better analogy of what occurred today can be found in the European Court of Human Rights case in v. Turkey. And the specific example where there is the speech of a political opposition member whose voice was targeted. And in that case,
Ms. Sweeney, I just wonder if your argument is a little detached from the actual facts here, where we have set out in the compromise really massive and constant misinformation being spread, sort of as verified by objective sources. So the argument could be, I believe the applicant's argument was, that this takes it out of the realm of free-flowing political dialogue. This is actually misinformation on a very, very elaborate scale. So should we be applying these precedents that you've cited that are developed in perhaps more balanced cases?
Your Excellency, the respondents would submit that the parallel is still relevant here because the applicant's contention is that this misinformation can be contributed to a threat to public order. However, it is the respondent's submission that when misinformation is directed towards a general dissatisfaction towards the government or the advocacy of an alternative political party, that cannot constitute in itself a threat to public order sufficient for restricting the speech. Now, I will briefly note on that, including in the general comment at paragraph 43, speaking precisely to information spread on the internet and blogs and other internet-based forms of communications, it found that it was inconsistent with the Article 19 to prohibit a site or information dissemination system from publishing material solely based that it may be critical of the government or political system espoused by the government. But Your Excellencies, I will then turn to the question of proportionality. If you find that in some regard it was necessary for maintaining public order to have some level of restriction on Professor Hunland's speech, we would still hold that the restrictions were not proportional in meeting that aim. And because this is a cumulative test, if you find that any of the prongs have not been met, the law weighs in the favor of the respondent. Now, on the grounds of proportionality, as mentioned by the applicant, the test applied is whether or not it was the least intrusive means available to render to meet the stated enumerated grounds. Now, it is relevant to note in two different accords. First, and related to the scope of posts that were deleted, we can see in clarifications at paragraph 10 that all of Professor Hunland's posts were deleted, not only those flags for misinformation or incitement to lawless action, therefore rendering 37% of his posts deleted without a cited reason. And further, in relation to the duration.
May I ask you a question which is at first sight a bit abstract, because you are now focusing on this particular case, but does the question of proportionality and of necessity not also depend on the kind of country or political situation in which the case is happening? There are large countries where we can expect that the public debate is so robust that misinformation is easily counterbalanced. Whereas in other countries, smaller countries, countries where the plurality of public opinion is not so ensured, misinformation can more easily throw off balance the whole political discourse, political situation, and the integrity of the election. Now, here we are confronted with two relatively small states, and where we cannot assume a political situation that we would assume in the United States or in larger European countries. Would you not have to make some take some account of let's say the situation of smaller countries, which may have some extra security requirements? And
Your Excellency, in that regard, I'm understanding of the concern and would like to acknowledge that the rule we're requesting this bench to apply today is a narrow one, speaking only relevant to the parties here at bar. And while considerations of capacity are relevant in consideration of proportionality, I would note that Antara and paragraph 10 of the compromise is cited as a technological hub of innovation and computer capacity, and further, in paragraph 1, of a population of 21 million, and cited by their own flagging mechanisms of the PANO post prior to the suspension, we believe shows that they did have the capacity to consider alternative means of regulating this speech. And while those facts may not be present in other situations, we believe that it is sufficient here to show that reasonable alternative means that would have been less intrusive were possible. Now, turning
Yes,
also...
Sorry, I think it's following on from my colleague Judge Nolte's question there. Would you address the question? I mean, in a sense, the applicant could argue that it had tailored its legislation fairly carefully. For example, the orders relating to the taking down of the posts and so on were of limited duration. Doesn't that suggest some element of care and tailoring to a particular situation? What should we do with that fact? Surely that's relevant to your argument.
Your Excellency, the consideration given by the applicant, while being relevant, it is worth noting in the general comment 34 at paragraph 36, found that a margin of appreciation should not be given in cases of freedom of expression, particularly noting the concern of the restriction of a political opposition speech. So while we recognize that those attempts were initially engaged, we would further find that a suspension for a year and a half after a referendum has already been conducted, there's no longer sufficient grounds to show a direct and immediate connection between that threat and the cited reason of taking it down for fear of inviolability of the referendum. Now, briefly, in closing this pleading, I will note that because the suspension is one of ongoing character, we respectfully pray, in accordance with RCWA Articles on State Responsibility, Article 30, that this unlawful suspension must cease, and we respectfully pray for this court to find in our favor. So now moving to the fourth, my apologies, did you have a question, Your Excellency?
Sorry, not me.
So we will now move to Ravaria's fourth and final submission before this court. Now, the key question here is whether or not Antara's actions in asserting extraterritorial enforcement jurisdiction was allowed under international law. Now, when the applicants enforced their domestic law PACA subsection 8 extraterritorially by hacking into over 5,000 devices located within Ravarian territory, they searched...
May I interrupt? Were these 5,000 devices hacked into individually?
Your Excellency, while the compromise is vague in some regards of the technicalities of the submission, respondents contend that that was the case given both the language of the annex of the legislation for PACA itself, giving it proclaimed authority to have extraterritorial ramifications in its enforcement, and further because of the technical issue that other botnets have been disabled by simply disconnecting the command and control center without individually hacking into all of the connected devices, such as in the mic.
So I understand that your case rests on the assumption that the 5,000 devices in your country have been individually hacked, right?
Your Excellency, that is the submission of the respondents today that we believe is well grounded in the facts of the compromise.
Okay, thank you.
Now, in this regard, we would like to first note that Antara's interference with these devices was in violation of their obligations under the Budapest Convention, which requires a state to receive or seek consent and cooperation prior to taking unilateral action when it comes to cybercrime enforcement activities. Now, both parties have ratified this treaty pursuant to paragraph 46 of the compromise, and we can see in Article 32 of the Budapest Convention that a party may access data stored in the territory of another state under two exceptions. The first is when that information is publicly available, for example, like a published website. And the second is in cases when they have obtained the voluntary consent. Now, in this case, Antara did not even attempt to seek cooperation prior to taking the unilateral action and taking down the botnet. Now, the applicants put forth a test today found under the Talon Manual about different thresholds of de minimis effects and what is required to show a threshold for violation of sovereignty. Yes.
Excuse me. We have talked about the Talon Manual with the applicants, and I would like to pose a question to you inspired by a response given by the applicants. The applicants said that the Talon Manual, its authority was enhanced by the fact that it was endorsed by the governmental group of experts. Can you confirm that this is the case? And if so, would you agree with that proposition?
Your Excellency, the respondents submit that the Talon Manual in its entirety is not reflective of customary international law. And we can see particularly on the issue of sovereignty that the UN group of experts on telecommunications cited that any non-consensual access to data stored on a server located in the territory of another state constitutes a breach of the territorial integrity of that state. That's page 409. Now, additionally, looking to the specific law of the Budapest Convention beyond customary international law in this case, but the text of the treaty, we can also see in Article 23 that there is an obligation for parties to cooperate with each other to the widest extent possible when it comes to
Sorry, Ms. Sweeney, before you go too deep into the Budapest Convention, I mean, an obvious challenge here to the actions of the state that you're representing are the clean hands doctrine. I mean, it does seem on the facts as we have them that the issue of clean hands might be raised here. So can you give us your view on the relevance of that in this particular case, and what effect does it have on your argument?
And may I add to that,
yes, please,
question
yes.
that personally I might have had a senior moment, but I haven't heard anything that looked like an answer to Judge Nolte's question.
I agree.
Madam President, I'll respond to your question first, but I would be happy to respond to clarifications for Judge Nolte as well. In relation to the clean hands doctrine, we would affirm what was said by the first agent for the applicant today, which is that this court has never found the clean hands doctrine to be a sufficient barrier for hearing the admissibility of a claim. And while it has been considered in dissenting opinions before this court, it has never been used with success to show admissibility. But I would further note, pursuant to
that's hardly an argument in principle, though, is it? Just saying you've never done it before. There's always a first time. So.
Yes, Your Excellency. While that may be true, we also hold that in this particular case, we first assert that the acts of the botnet are not attributable to Rivaria as articulated by my co-agent. Now, in the alternative of this case, we would encourage the court to think additionally of the policy concerns of preventing, while still considering the merits of Antara's claims related to our actions with the botnet, whether or not that should bar another state from additionally having engaged in unlawful activities. Now, Judge Nolte, I would be happy to respond to your question if you would mind clarifying.
Yes, my question was a bit more abstract than your answer, and that's completely understandable that you, let's say, wanted to go back to your case. But my question was, you invoked the Talon Manual, just as the applicants also invoked the Talon Manual, and we had a debate about the legal validity, authority of, for the purpose of interpretation of the Talon Manual. And the applicants made the interesting point that the Talon Manual was endorsed, had been endorsed by the governmental group of experts. I don't know what the source of this statement is. I wanted to know, can you confirm that? Do you know whether that is true? And if so, how would that affect the interpretative value of the Talon Manual? Thank you.
Thank you for your clarifications, Your Excellency. On the first prong, I am not privy to whether or not this was an action taken in adoption of these principles for the Talon Manual. But to the second prong, even if that were the case, Your Excellency, there are particular issues within the Talon Manual that are highly contested, both by state practice and alternative states, particularly on the issue of sovereignty. And we would there hold that even if it was acknowledged by states, it is not shown to be a codified principle of customary or of a subsidiary means under Article 38(1)(d). And noting my time, Your Excellencies, may it please the court. Thank you.
Thank you, Ms. Sweeney.
No, take it off. Take it off. Oh, the paper. Thank you, Your Excellencies. 2 points in rebuttal. First, we note Your Excellency's early exchange with the first respondent on the Bound number 3 case, which we certainly hate to bring this court back to Oxbridge jurisprudence, which the respondents here argue represents a categorical approach to the exclusion of evidence. However, as Madam President pointed out, this court is distinct from domestic courts in its application of domestic law. And in Bangkut number 3 itself, the court noted that the categorical prohibition read into Article 24 of the VCDR was, and I quote, restricted to the domestic court of the host country. And this view is shared by, for example, ex-President Spender in the Southwest Africa case, which Madam President earlier put to the respondent, the 2012 European Court of Human Rights El Malsuri case, and the 2013 CJEU Bank Malat case. And all these speak with the same voice that international tribunals have far greater discretion in the admissibility of evidence. And here we urge Your Excellencies to exercise that discretion in accordance with the comparison of illegalities test, which here clearly favors admitting the documents. And to my second point of rebuttal, now when queried by this bench on the massive and constant misinformation being spread, the respondent maintained her position that false speech cannot be restricted on this basis. But Your Excellencies, the weight of the authorities clearly suggests otherwise. For example, the European Court of Human Rights cases in Stanskretski and Poland and Brensky and Poland, and the 2021 Special Rapporteur Report on Freedom of Expression, which reads that electoral laws may justifiably forbid the propagation of falsehoods relating to electoral integrity. And as Judge Nolte queried the response, information can easily throw off the integrity of elections. And where this election would determine the fate of an entire province, Your Excellencies, this must be considered necessary. Thank you, Your Excellencies. This concludes my submissions. May it please this court.
Thank you, Ms. Wong.
Your Excellencies, can you hear me?
Yes.
Ms. Sweeney. Ms. Sweeney.
Your Excellencies, in relation to the first point, the respondents did not argue for a categorical rule. And in the Bangkok 3 case, the UK High Court was considering the interpretation of the VCDR. And further, as can be found in Judge Schumer's commentary on the draft, the ICJ should not be an accomplice to a breach of international law. Now, in relation to the second argument of free speech and whether or not misinformation can rise to the threshold of a threat to public order, we confirm the applicant's assertion that there is precedent to show that there are cases where there may be shown a direct and an imminent connection between that speech and the threat to public order. We simply hold that the applicants failed to show that connection between Professor Hunland's speech and the allegations asserted today. But further, I would note that even if they did, it was not proportional in meeting that need. Your Excellencies, we respectfully pray for you to find on behalf of the respondents. Thank you.
Thank you, Ms. Sweeney.
The Honorable Court is now adjourned. The judges will now exit the courtroom to deliberate and will inform the parties when they are ready to return to the courtroom to provide brief feedback.
On March 7th, 2022, like many of you, I watched the oral arguments before the International Court of Justice on Ukraine's request for provisional measures against Russia. I was struck by the powerful message delivered by the agent for Ukraine, Mr. Anton Kornievich, who, in denouncing the war of aggression that had been unleashed against his country 11 days before. My message to Russia is this: let us settle our dispute like civilized nations. Lay down your arms and put forward your evidence. Ukraine respects this court and follows its orders. Russia must as well. He said this to empty seats, which should have been occupied by lawyers representing Russia. 9 days later, on March 16th, in the Great Hall of Justice of the Peace Palace, the president of the court, Her Excellency Joan Donoghue, read out the ruling on Ukraine's request. The court ordered the Russian Federation to immediately suspend its military attack on Ukraine. The court's order was delivered, again, to empty seats on the Russian side. The symbolism of those empty seats should be lost on no one. They, compounded by Russia's refusal to comply with the court's order, represent a rejection of a rules-based international order in which disputes are resolved by negotiations, adjudication, and under the authority of the United Nations Charter, not by the unilateral and illegal threat or use of force. And it is the abandonment of international law that has led to the atrocities that we have seen occur too many times in history. And we are witnessing yet again, now being carried out by the Russian army against the civilian population in Ukraine. Our Jessup community has been touched by the immense human suffering in Ukraine in a deeply personal way. The lives of our Jessup students from Ukraine and their steadfast coaches and advisors are in danger, and their futures have been cast into doubt by the Russian invasion. Our Ukrainian students were unable to participate in the Jessup this year, but we have seen their faces, heard their voices, and read their words. We have been touched by their eloquence, their poise, and their message, which was delivered as one would expect from dedicated students of international law. It is precisely when the international legal order is at its most fragile that students of international law are summoned to defend it to the best of our abilities. And it is when we see international law being disregarded that we are reminded of the unique mission of the Jessup competition and the International Law Students Association. I am here to ask you to take what you have learned from your studies and from your participation in the Jessup and become advocates at home and abroad for a world governed by law, not military force, and to inspire others to do the same. Since its founding in 1960, the Jessup has brought together law students from around the world who share a passion for international law, even when there is vehement disagreement on what the law means and how it is to be applied in a given factual circumstance. ILSA has remained steadfast to that mission because we believe there is an ever-present need for the practical learning in legal research and advocacy that the Jessup can provide. But the Jessup competition is more than just an educational experience. Its entire purpose is to instill in law students the unshakable belief that international disputes can and must be resolved by peaceful means, by argument and by evidence, not by force of arms. The Jessup cannot change what governments do today. Our aspiration is to change the lives of individual students who will one day determine what tomorrow's world will be like. It is you, Jessup students, who are our best hope for a future without empty seats at council tables at the International Court of Justice. It is you, our Jessup students, who are our best hope that states will always comply with the court's decisions, even when they are not what some nations may have wished. I know this aspiration may seem naive to some, and I know that some found it difficult to accept Ilse's decision to allow students from Russia to participate in the Jessup this year. But we must hold fast to the belief that each and every student who competes in the Jessup has the potential to become the lawyer, the diplomat, the judge, the professor, or the political leader who insists that disputes between nations must be resolved in accordance with international law. If we abandon that aspiration, we would be effectively conceding that there really is no point to the Jessup at all. But there is a point to the Jessup. There is a reason why hundreds of alumni come back every year to coach and to judge, to encourage and to teach the next generation of students. We are convinced that instilling in students a commitment to engage in respectful advocacy of diverse views before impartial judges is the only path to peace and progress for all nations. If we want international law to survive, we must continue to train the next cohort of lawyers and of policymakers and inspire them to pursue an agenda of peace, of equity, and respect for human rights. If we were to abandon that commitment now, we would consign ourselves to a world where armed force, not reason, becomes the accepted solution to international disputes. We cannot and we must not do that. My friends, we have just witnessed the two best teams in the Jessup in 2022. In a few minutes, the three judges, two sitting judges from the International Court of Justice and one retired judge, will return with their verdict. The presence of their excellencies here today speaks volumes about the value of the Jessup. These two talented groups of students, their coaches, and all of those who helped them reach this level of the competition deserve our congratulations as well as our thanks for epitomizing the reasons why so many friends of the Jessup remain passionately committed to this remarkable global community. And while I'm expressing appreciation, let me take a few more minutes to thank the people without whom this Jessup competition could not have taken place. Most of you are aware that this is the first final round in 10 years conducted without the guiding hand of Leslie Benn, our former executive director. Leslie is the one who not only expanded the Jessup to nearly 100 countries by 2019, but literally saved the competition in 2021 by leading the shift to an online format in response to the COVID-19 pandemic. Leslie, the entire Jessup community around the world thanks you with all our hearts. When the Jessup returns to an in-person event, as we all hope it will in 2023, hundreds of us will be there cheering for you as you are recognized in the ballroom as among our most beloved friends of the Jessup. By Leslie's side for much of her tenure has been Tessa Walker, ILSA's interim executive director since February. Tessa has faced many daunting challenges this year, but she has continuously proven herself to be a remarkable and stalwart professional. A leader to our dedicated ILSA staff members, Chris Bonet and Shannon Hutchins, and a calm and steady guide for the competitors, the coaches, and the judges throughout this year's Jessup. Tessa, you have always been indispensable to the Jessup, but this year you truly went above and beyond the call of duty when ILSA needed you the most. I speak for your friends and admirers everywhere in saying thank you. And finally, it is my pleasure to formally announce that the board of directors has unanimously selected Michael Pyle to be the next executive director of ILSA. Michael returns to the executive office after having served there between 2001 and 2006, and after a successful term as vice founding dean of the Jigme Singwe Wanchuk School of Law in Thimphu, Bhutan. Of course, as everyone in the Jessup community knows, Michael never really left ILSA. He continued without interruption as one of the most dedicated and committed friends of the Jessup. But with Michael's new mandate as ILSA's executive director, and with Tessa, Chris, and Shannon working with him, the International Law Students Association will be doing even more in the coming years to promote education in international law around the world. My friends, thank you for your support of the Jessup and the International Law Students Association. I hope we'll all be gathered in person next year. But until then, let's savor the moment, which is coming soon, when their excellencies return to the courtroom and declare the winner of the 2022 Whiting Case Jessup World Cup.
So, can I just check that we're audible, or at least I'm audible? That yes, great. Okay, thank you. Well, thanks everybody for what for us here in Europe has been a wonderful afternoon. I'm going to first, I just should say it's quite exciting for me to preside because I'm actually on the International Court of Justice. I'm judge number 15, the most junior judge. So my dear colleagues have very kindly elevated me momentarily to this position. So using my power as president, I'm going to call on my respected colleague, Judge Nolte, to begin with. And we want to give you our impressions overall of the moot before we announce our decision. So Judge Nolte, please, you have the floor.
Thank you very much, Madam President. I'm judge number 14, and I would like to express my gratitude and my admiration to the teams. I've been a participant of the moot court myself when I was younger, and I am so impressed. I have not reached the finals with my team, but I've watched the finals with my team, and you are so much better than we were a generation ago. I really mean it, and I have the impression that because you have become so much better, it has become more difficult for you. The judges, when they ask questions, they are turning you away from your presentation, sometimes towards a more abstract question, and it is your responsibility to bring us back as soon as possible to the specifics and to the case. And the judges, they want their questions to be well answered. They don't want to be shortcut, but on the other hand, we understand that time is short, and I have noticed that time is frustratingly short if you're on the bench. I would have liked to hear so much more, and a few points I would I will do some research whether the answers I have been given are well-founded or not. I'm curious, but in any case, I found that I have met with counsel who were really up to their job, and of course with nuances with respect to different questions. I will not go into specific questions. I felt supported as a judge by your presentations, and to render a judgment, an imaginative judgment in this case. I'm very confident about the young international lawyers, the generation of the young international lawyers. I don't want to make any individual assessment now, just to say that all those counsel which have spoken have been very close among themselves or between themselves with respect to the quality of their arguments and the way they have presented their case, switching all the time appropriately and with nuances between mastering the specifics and justifying the approach to the specifics by more general considerations, and that mastery was quite impressive. Thank you very much, Madam President.
Thank you, Judge Nolte. Judge Simma.
Well, I can join Georg almost totally. I'm deeply impressed. I've had the pleasure of judging the finals maybe now about 4 or 5 times, but it has been about 3 or 4 years since I last did, and I have to say that there is an increase in the quality and in the perfection with which you play your roles from year to year. And what I have heard this time is just amazing, even though in my view sometimes it's just it's going, I don't know what that, an Oxbridge expression might be, going over the top. I don't know whether that fits here. I think you go too far. For instance, I think as a judge, I would be happy if you say this and this is the case, and you wouldn't have to give the page numbers, like let's speak out the footnotes that you would find in the official transcript of the judge. So it's perfection. It's a bit of a hyper perfection, and maybe the people in charge, ILSA people, could think about that. But as I said, the quality is just overwhelming. I've got a few points that I want you to take as a well-meaning criticism. Not, they're all general points. It's not on team 1 or team 2. It's just general. You are so good. You know so much more than I ever did and ever will know. Is it necessary for you, when you get the question, to always refer to the compromis or the clarification? Say, well, according to the clarification, this is the case or this is not the case, which reminds me, like school children, just keeping on a little rope while crossing a street. So I think you should just say what you think things are. And if the judge or later on a member of another team says, I don't know where have you got that from, you can still say this was on page 4 or 5 at the bottom, but not add it to every claim you make. So I think this is just so compromis clarification, not necessary. Then who told you to address us all the time with Your Excellencies? It's not done before the ICJ. Maybe in front of the ICJ, counsel says it once, or maybe if the counsel is French, he says it 7 times, but not the way you did. I think I've never heard so many excellencies. Of course, my blood pressure has risen. I find almost close to Georg now, because the excellency I enjoy now is a bilateral one at the Iran-US Claims Tribunal, and of course that in front of the ICJ it's worth more. But just leave it, forget it about that, forget it like the may it please the court, which is American. I have a suspicion. So the Jessup moot court competition is something to bring, the young people from all over the world into the field, etc., etc. But I always have the suspicion that there is also an interest on the Americans in this Jessup enterprise to remind people, well, essentially this is an American thing, and which of course means America is a leader in this entire educational effort, etc. By doing this, may it please the court and Your Excellencies. It may be American, but it's not Hagian. Okay. The next point, and that's already my second last point, is before the ICJ, if somebody refers, for instance, for the first time to the Covenant on Civil and Political Rights, I'm sure the council would say, and as you see in Article 19 of the International Covenant, blah, blah, blah. And then he would say, and in the following, he might use an abbreviation. But at the beginning, for instance, just to give one example, one of you, I think it was one of the respondents team, referred to the Republika Srpska and another thing in a context far away from our beautiful, thing, and just abbreviating it. I knew what they meant, but I think it's a matter of politeness to the judges, and okay, fine. The last thing I want to say is amazed how women take over. I'm very sorry to say, just count the people. I think we men have to do some emergency measures, really. Women are so good. And I think we should all apply for the P2 jobs at the ICJ, because I'm doing a lot of recommendation letters, etc., etc. And you have the feeling there is now a stream of lawyers that it starts with, of course, university studies, but then it's Jessup. The next thing might be an internship at the ICC or ICJ, and then you find people as if they are not so lucky as partners in a big law firm, if they're luckier as arbitrators and judges. So please keep keep to that road. It's wonderful. We need you up there once we are gone. Okay, thank you.
Thank you, Judge Simma. I also concur completely with my colleagues. It's been a great pleasure. It's quite funny. This is the first experience I've had of we've been listening to arguments all week in the International Court of Justice. In fact, all three of us are involved in a case now. And I was thinking, so coming from, if you like, real life oral argument, and then coming to today is, it's very striking, the extraordinary quality of Jessup argument. And like Judge Nolte, I too was a Jessup mooter, and I think in today's competition, yes, I would have dropped out very, very early in the rounds. Just the astonishing quality and polish. So I just want to congratulate you all. It was a huge pleasure listening to you, and the mastery of the law, the deep knowledge of the law that you have. And I also want to just note that you, under sometimes questions coming from here and there at different levels, you all remained admirably calm. I thought you showed great fortitude. The one piece of advice I'll have is sometimes it's just to go with the flow a little more. I'd say this, I know all of you felt you had two arguments you had to address and you wanted, well, thank you, judges. We're a bit sick of questions on that. Now we'd like to move on to that. But at the Jessup moot, you'll never be graded down if you just go along with the judges and indulge them, even if you think their questions are not very interesting ones. They'll be interesting for the judge. And so you're not catching a train. You don't have to complete the argument. That's the main word of advice if you go on mooting. But all of you have reached the pinnacle. But it was a great pleasure. And like Judge Simma, I do feel that the next generation, it gives me great optimism. I think the next generations of international lawyers seem absolutely assured listening to all of you. Now, I'm really sorry that we had to come to a decision here because we had a few technological problems, which explains our delay. But I think it's fair to say we were very, very torn but we were told we couldn't get out of just saying we'd like to give you all the Jessup cut. We were told that wasn't an appropriate route to go. So we'd really like to emphasize this is very genuine. It was an exceptionally close competition. I'd like first to announce the speaker to whom we'd give the Best Oralist Award, and that's Ms. Marta Canary of the respondent. We'd like to congratulate you, but that's acknowledging that all the speakers were exceptional. So, but congratulations, Ms. Canary, for a really outstanding oralist. And then again, I emphasize how difficult we found this, but we decided by a whisker, as we'd say in Australia, that we would give the overall moot to the respondent team, to Bavaria. So congratulations to the applicants for such an extraordinary performance, and you've done your university and your country and yourselves really proud. So many thanks to you all, and very much to my fellow judges who made judging it such a pleasure. So good evening.
May I ask what university or what team or what country they come from?
Oh, yes. So, yes, we were kept in the dark. So we made perhaps some rough guesses. But so may I ask the applicant team, where are you from?
Oh, we're from Singapore, the Singapore Management University.
Okay, well.
Congratulations. Are you only two of you?
No, there's a whole team of us seated around the periphery.
Oh, I see. So congratulations to them as well. You did an excellent job.
It's an outstanding job. And you could tell, I would just say, the excellence of the teamwork was really, really impressive. So congratulations to you all. And the respondent team, where are you from?
We're from the United States. We're from Harvard.
Okay. We may be, I may be guessed United States, but okay. Yeah. Okay, warm congratulations.
But it's great to see that Harvard seems to be catching up again.
I know. It came from us, but we've never actually won before. So.
And congratulations as well to the applicants today. It was such a fantastic round.
Thank you very much. You too.
Okay, warm congratulations to all, and we hope we'd love to see you. We'd love to see you applying for jobs at the court, all of you. We think you'd be great assets, and wish you very, very well in your international legal careers that we hope you will have. So thank you, fellow judges. And I think now we magically disappear off the screen and return to our real lives here in Europe. Okay, well, thank you. And just let me say, the organisers, Tessa and Michael, have been utterly superb and saved us from many technological vicissitudes that we encountered. So we're exceptionally grateful for the superb work of the Jessup backup organisation. So thank you very, very much for fantastic work. Well,
Thank you so much
for being here. We really appreciate it. Thank you to both teams and to all three judges. This was an exceptional round, and we are incredibly grateful for all of you taking part.
Thanks, Tess.